Yes, counsel. Good morning.
May it please the Court. John Fennell for Petitioner-Appellant David Gangi. This Court's prior rulings lay down a clear rule for violations of the Chapter 123A, Section 13A commitment deadline. Any violation of the 60-day commitment deadline results in dismissal of the Commonwealth's case unless there are extraordinary circumstances justifying a very brief delay.
And the circumstances in this situation had to do with the clerk who didn't log in the information in a timely fashion?
That's correct, Your Honor, and that's the same error that occurred in the Kennedy case, the first in several cases this Court has looked at reviewing these deadlines. In Kennedy, the clerk made an error, and the communication that probable cause was found was not transmitted to begin the qualified examiner's evaluations. The Commonwealth argued in that case that the clerk's error absolved the Commonwealth of responsibility for meeting the 60-day deadline, and this Court rejected that argument. In Para, there was a failure of communication. The Department of Correction was not told to begin the observation period, and this Court again said that was not extraordinary circumstances relieving the Commonwealth of their responsibility for meeting the 60-day deadline.
Now, where is it written that it's the clerk's job to notify the QE of probable cause?
Not in the law, Your Honor. This seems to be the mechanism that is, in fact, used to administer this process. It need not be this mechanism. It could be something else. I don't know exactly how it works.
The court that does it, because the court theoretically appoints the QEs? In other words, whether it's the clerk or, would it be the court that notifies the QEs?
It could be that way. It's not that way. There's nothing in the statute saying it's that way. The statute.
It's the DA that does that. Is that right? Once they get the notice that probable cause has been found? Is that, practically, how does it work?
My understanding, and I only infer this from what I read and see, is that what typically happens is that the clerk dockets the finding of probable cause. An order is transmitted to the Massachusetts Treatment Center telling them to appoint to put the QEs on the case. The qualified examiners are paid for through the Department of Corrections contract. That's outside the record.
But you essentially need a piece of paper from the court that says court order on it, or words to that effect, that authorizes the 60-day the 60-day examination to begin.
There's nothing to say that that's the case.
Well, if that isn't the case, then why don't they just start it, any day? What are they waiting for?
Well, there needs to be Section 13A requires that the judge be satisfied that the probable cause standard is met, and once that happens, it shall be committed. It's mandatory. So once the
let me give you a different illustration. Supposing the police go to a judge and say, "I'd like a search warrant." They show the judge the search warrant, or they show the judge the application for the search warrant. The judge says, "Yeah, this looks pretty good. I think I'm going to issue a search warrant." Can the police then go start the search?
I don't think so in that case.
They need the warrant, don't they?
They would.
And don't you need the order here to start the examination?
Well, the judge, in this case, the judge made the oral order. The Commonwealth could say, "Hey, Judge, could I get that in writing?" Hey, there are various things that the Commonwealth could do to ensure this happens. The Commonwealth could have looked at the docket entry in January, and then the Commonwealth attorney didn't do that and would have seen that nothing had happened and then could have followed up on this. There are all sorts of things a conscientious attorney could do to make sure the qualified examiners began their inquiry after probable cause was found on January 7th, and that didn't happen. So
if the Commonwealth if the prosecutor had, based on the judge's statement, oral statement that the order is going to issue, the Commonwealth then calls the institution and then says, "Okay, start the interrogation going," and the docket, the order is never issued and nothing is ever docketed. Can't the examiner say, I'm not going to do this without a court order?
The examiners, and this is outside the record, but my understanding is the examiners don't get a court order. They get a phone call.
A phone call.
And it said, go in there and do it or not. In this case, and in prior cases, in the Gagnon case, the Commonwealth attorney did call the Department of Correction requesting expedited examinations, and those examinations and the reports were filed in Gagnon within 8 days of that phone call. And here, after Gangi filed his motion to dismiss, the Commonwealth attorney requested expedited reports, and they were again filed within 8 days. Had the Commonwealth attorney promptly acted when the 45-day deadline for the qualified examiner reports expired, there's plenty of reason to believe those reports could have still been procured in time for the Commonwealth to meet its 60-day deadline.
Now, under 13B, the court has an obligation to pass on court and juvenile records to the QE, and the Commonwealth is supposed to pass on police reports. Do we have any evidence that that happened here?
I don't know of any evidence on the record here. I know that practically those get given to the QEs by the DAs prosecuting the case, and then they'll also...
So the DAs under 13B are supposed to be in touch with the QE to provide them with the police reports the QE needs to review.
That's what I've seen historically
Wouldn't
happen.
you know that here, though? Because there were QE reports. I mean, I don't know whether they're part of our record, but they would indicate whether it got to the QEs or not, wouldn't it?
It would, Your Honor. The QE reports are outside the record here, but typically there is communication from the district's attorney to the QEs, providing them with this discovery.
Now, what do you mean? What do you think we meant by brief delay or very brief delay?
Your Honor, the PARA decision says that the extraordinary circumstances justify the very brief delay. So I think that the very brief delay must be something commensurate with the extraordinary circumstances that give rise to the delay occurring. So if there's a delay, there's some kind of state emergency where the courthouse is closed down for 2 days, then that would seem to justify a 2 or 3 day delay, a very brief delay, to then get those reports or the petition for trial in, something commensurate with the event that led to the disruption.
You actually don't even need, if your argument, you don't even need to get there, right? Because you say there's no extraordinary circumstances to begin with.
That's right, Your Honor.
Ordinary negligence of not docketing this order doesn't qualify as extraordinary circumstances.
That's right, Your Honor. The rule set forth in PARA is that there must be, the first part of the inquiry is, were there extraordinary circumstances? And if there were not extraordinary circumstances, that's the end of the inquiry. But assuming that there are extraordinary circumstances, then it's the extraordinary circumstances justifying a very brief delay. And our position here is that neither of those occurred.
Does it make, obviously you're going to say no, but why doesn't it make a difference that your client himself sought whole bunches of extensions before we got to this point?
That's right, Your Honor. And what was going on there was Mr. Gangi was exercising his liberty interest by preparing his case. In the record, we see that a motion for funds was filed to retain an expert, and Gangi was preparing for an adversarial hearing where his liberty was in question. If there's probable cause, then the Commonwealth then it's mandatory that he's committed for 60 days, and that's a 60-day observation period where he's held for the gathering of the Commonwealth's case against him. And Gangi was preparing his case before that, getting things in place to argue probable cause and other information.
And it's irrelevant that he ultimately stipulated to it.
It's irrelevant. Once that 60 days is the liberty, the respondent in a initial commitment case can be at liberty before probable cause. It doesn't happen often, but it has happened and it can happen. It's allowed by the statute. Preparing his case for this hearing where he can lose his liberty while the Commonwealth gathers the evidence against him to have him potentially committed from a day to life.
What if we don't agree with you? What recourse would a defendant have if, let's say, it took a year for the clerk to docket the order? Is there any other recourse under the statute?
Under the statute, there's no alternative to dismissal. That's what this court said in Para. There's no alternative to dismissal because there's no alternative to commitment.
That's not my question.
Okay.
Is there you're basing your theory on the fact that, or on you're basing your theory on the fact that the judge found probable cause on January 7th.
Yes.
And that's the trigger date. What if we don't agree with you? And what if we were to say that it is the date that the order issues to the independent examiners or to the department to begin the examination? That could take a year. I mean, there could be some kind of an administrative problem. It fell through the cracks, and he's incarcerated for a year. Is there any other remedy, any other statutory remedy for this kind of a problem?
No, Your Honor. When this court looked at the deadline and who's responsible for meeting this deadline, after what the statute says is the judge is satisfied there's probable cause, it put all the responsibility on the Commonwealth to meet that deadline.
But what if, I think what the question is, assuming that the judge finds probable cause when it's docketed, you interpret it that way, when it's docketed. So he has the hearing, maybe he doesn't say anything. He just, he doesn't say anything. He makes the decision the next day, but it doesn't get docketed for a year. Is there any statutory remedy? Because he's not being held pursuant to probable cause at that point. He's being held separately. As you just said, he doesn't have to be held, but he is being held.
Yes, Your Honor. So this court has looked at other delays between a hearing and when the judge ultimately makes a ruling. One was the Blake decision from 2009, where the SDP trial was had, and then the judge didn't issue the order, his ruling on the merits, for about 13 months, I believe. And there, this court said, absent extraordinary circumstances, the judge must issue the ruling on the trial within 30 days. There was also a case where this court discussed the 5-month delay between probable cause, the hearing, and the judge's actual ruling. That's the Puissant case, and this court found that delay inexcusable. But looking at Blake, the determination a judge needs to make to find probable cause is a much less onerous burden for the Commonwealth. It's a Lanigan standard, and they only have 30 days. The judge only has 30 days to rule in the trial, so it ought to be shorter.
So I take it what you're saying is, even with my concern about they need a piece of paper to start the examination, it is deemed to have been issued on the day that the judge announced publicly what his decision is.
It's
or
the
should
law.
be.
It should be. The mechanism, whatever mechanism starts transmitting this order, isn't covered by the statute. The statute simply says if the judge is satisfied there's probable cause, the respondent shall be committed. And in looking at the responsibility for meeting this deadline, this court has placed all the responsibility on the prosecution for making that.
And here it was understood by everybody involved in this case that a probable cause determination had been made on January 7th.
Well, at the motion to dismiss, the original motion to dismiss from the papers, you can see that the Commonwealth does dispute that then, but the the judge who ruled on the motion to dismiss went back and listened to the transcript and said, yeah, all this did happen, probable cause was found, the judge made the orders. The problem was that the clerk didn't execute the practical mechanism that exists that doesn't exist in the law.
All right, thank you, counsel.
Thank you, Your Honor.
May it please the Court, Kenneth Steinfield for the Commonwealth. I'd like to begin by addressing Justice Botsford and Justice Spina's concerns at the outset of my brother's argument as to what should happen when probable cause is determined. What commonly happens is that the clerk of court makes a docket entry, and then the clerk of court notifies not the treatment center, but the DOC. The DOC then notifies the treatment center, and the DOC, in fact, appoints 2 qualified examiners. I believe it's Section 2 of 123A says that. So that is typically what happens and what should happen, and there does need to be a judicial order. I think Justice Gantz pointed out that if the Commonwealth just calls and says, oh, PC has been found, please start the process, they're going to say we need an order. So the statute which says that the QE...
Is the order ever in the record? Is there an order now in the record?
There's an order from March 7th, backdated, from March 2, that says probable cause having been found on January 7, the defendant is now committed for 60 days pursuant to 13A.
But I had thought you would agree that the appropriate date is the finding of probable cause, that we should
Yes,
have
I do.
60
The
days from
statute,
that.
So January 7th is the probable, is the right date here?
Yes, I've got to admit, and I do so reluctantly, but if you look at 13A, 13A is very clear. It says when the judge is satisfied that probable cause exists, then he shall commit the respondent to 60 days. So as soon as Judge Inge on January 7th was satisfied that probable cause existed, that's what started it over. The Commonwealth did argue below when it opposed the motion to dismiss that March 2 was the date. Now, in hindsight, because given the wording of 13A, we all agree that the operative date is the 7th of January and not the 2nd
Well,
of
what
March.
was the extraordinary circumstance that would justify a brief delay?
Well, the extraordinary circumstances were, as I say, a confluence of events. In Parra and Kennedy, well, let me start off by saying the fact that the clerk made no docket entry and made no attempt to fulfill her obligation to contact the DOC. That has happened in prior cases, I must admit.
So let me stop you there. So if the fact that the clerk didn't make the proper docket entry is a valid reason.
Not standing alone, Your Honor.
Okay, not standing alone.
Yes, I'm sorry to
Right,
interrupt
please
you, but I
continue
wanted.
then.
But if that standing alone is not enough, the case has made clear that there's a joint responsibility between the clerk and the Commonwealth to make sure that the QE reports are filed within 45 days and that the petition for trial is filed within 14 days after that. Here, I think a very key date that I'd like the court to focus on is the 15th of February, which was the 39th day after probable cause had been found. Now, there's nothing in the record, but I would add that this case has been impounded, and there's an order to that effect on the Superior Court docket. So the docket is not available to the Commonwealth from its office. Of course, the DA probably could have gone to the civil clerk's office and found out. But it's not just a simple matter, as my brother might have the court believe, for her to check the docket. But on day 39, there was a status conference where the ADA, the first thing she did is she asked the clerk and the court, have the QE reports been filed? Because she knew that these are very serious deadlines. The clerk at that point, whose job it was initially to docket the finding of probable cause on the 7th of January and then to start the ball rolling, said, no, we haven't received them yet. She said nothing about no docket entry having been made. She said nothing about I will look into it. She just said, no, they haven't been received. And that's how the ADA chose to fulfill the Commonwealth's obligations. She could, of course, have called DOC herself, and then she could have had the court immediately send over some kind of an order that says a probable cause has been found on January 7th. But she brought it to the court's attention in a timely fashion when the court itself could have corrected the problem.
But Mr. Seinfeld,
I'm sorry, go ahead.
well, I guess my question is, and Judge Kern's, it seemed to me her decision was sort of premised on this, is drawing a distinction between the Commonwealth being the prosecutor and the clerk, which somehow isn't the Commonwealth. Well, vis-a-vis this particular person, isn't that all the Commonwealth?
Well, as I say, the injury that results is the same. But I
But
think...
I mean, why, as far as he's concerned,
Oh,
whether
sure.
it's the clerk or the DA, it's his liberty. I mean,
Absolutely.
I just don't get
It
that
doesn't matter.
distinction. I don't get that distinction.
Well, I don't think that distinction is necessary to a finding that there are extraordinary circumstances.
Negligence is extraordinary?
It's not just negligence. It is the fact that the Commonwealth here, the prosecutor at least, did everything within her power to make sure that these things were done. And the clerk, Judge Kearns found explicitly that the delay was solely attributable to the clerk's error and was of no fault of the Commonwealth.
That's my point. Vis-a-vis Mr. Gangi, whether it's the clerk or the DA doesn't make a bit of difference.
That's true. But it is an extraordinary circumstance. On top of those things that I've already mentioned, on day 52, 13 days after that status conference, the ADA was concerned that no QE reports had been filed, so she contacted the clerk of court again. This was 52 days after the finding of probable cause.
Well, you know, it might be one thing if there had been a fire in the courthouse, something, an act of God that was beyond the circumstances of state employees. But why shouldn't the burden here fall on the shoulders of the state, whether it's the clerk or the prosecutor or both?
Well, this court has not previously held, well, they've said the Commonwealth has the duty to make sure that they're filed on time, but if the circumstances are extraordinary, then it doesn't matter whose fault it is. I think this court could make the distinction between the Commonwealth and the court. The statutes that I've cited talk about the district attorney represents the Commonwealth in court, and the Commonwealth is not part of the judicial branch. But I agree the injury to the respondent is the same.
It seems to me it's sort of like a double jeopardy argument about whether there was or wasn't manifest necessity. It could be, you know, the argument could be the prosecutor goaded, or it could be that the judge made a mistake. But either way, it's going to end up, I mean, assuming that to be valid, it's going to end up with a double jeopardy problem. Doesn't matter which one it was.
Right. He's been held 16 days longer than he should have, regardless of who's at fault, and he doesn't care.
Yeah, you know, it almost sounds like you're saying the extraordinary circumstance here is a bad clerk, and that going forward, if you prevail, then a basis for concluding that there should be a brief delay would be the category bad clerk. Would you agree with that?
No, I would say there are three bases, and I would definitely not say bad clerk. As Judge Kern found that it was an inadvertent error that the clerk made.
3 times.
No, she failed to docket it once.
And then when she was inquired.
On day 39, did not then further make any inquiry.
And then again on day 52.
Right. And then the extraordinary circumstance on top of that, I think, is first the zealousness of the prosecutor, which is nowhere to be found in the prior cases. It seems that in the prior cases.
But you say that, but is there any evidence that under 13B the police reports were sent to the QE? How does that work?
No, there isn't. Ordinarily, once the QEs are appointed, they contact the DA or the DA contacts them, and that information is shared.
But the DA then never got a telephone call.
That's true. She did not. So she brought it to the court's attention, thinking this is the way to remedy it.
But she knew then by day 39 that she had not even gotten the telephone call to provide the police records, which she knows or should know are necessary to the QE.
So to remedy that, she brought it up with the court. There's nothing that says the only way to for there to be a finding of extraordinary circumstances is that she has to call the DOC herself. She could have done it, but that is not the only way that she could have tried to
But all
remedy
she
the
asked was,
situation.
has the QE report been filed? But how could the QE report been filed if she hadn't provided the police reports?
Well, she's got to know who the QE is before she can send the QE anything.
So the procedure then is the DA learns who the QE is, and then the DA or the ADA sends the police reports.
I believe that's how it works.
So you
but-
didn't, and so therefore, since nobody had asked you who the police, since the police reports had not been sent, there was no QE. The ADA should have known that.
Right, and the DA did know that, and so she brought it to the attention of the court with the reasonable expectation that the court would act to remedy it. When the court sought to remedy it,
Why was that the reasonable expectation? If she knows at that point that she hasn't heard anything and that there is no QE report, why isn't, knowing the strict deadlines,
sure.
why would you expect a shorthanded court to be the one to remedy this as opposed to just making the call to the DOC to find out what's going on?
Well, I think because it is the clerk's initial obligation that it's not unreasonable, and the ADA have been working with the first assistant clerk on this matter, as the record shows. And the first assistant clerk, when she brought it up to her, did not say, oh, you contact DOC right away. She went and she consulted with Judge Inge. And Judge Inge decided to solve the problem by starting the clock back all over again, which I argue is the third extraordinary
But
circumstance.
I don't understand what you mean by that.
Well, when on day 52, the ADA contacted the first assistant clerk, she did not say, the clerk did not say, you got to contact DOC right away. She raised it with the judge who had initially found probable cause. And the way the court sought to remedy the problem was not to notify DOC immediately, which it should have, but rather to redock it basically on March 2.
But it docketed as of, okay.
It said that the 60 days starts over again, and it said that on March.
I thought it said,
Two.
I thought the order read back to January 7.
It did refer back to it, but it said by its explicit terms, the respondent is now committed for a 60-day period of evaluation and examination.
I understood
so
that
while
to go start back.
Right, this order, I claim, was error. It should not have said what it did. It did refer to the finding of PC on 1/7, but it purportedly to start the 60-day clock over again on March 2. And I think it was fair for the ADA to rely on that. Nonetheless, she sought to expedite it, and the delay here was only 16 days. And I know that I only have a few minutes, so I'd like to discuss why I think that's a very brief delay. Primarily, I think that if you look at 13A and 14A, the whole point is to have a trial done or started within 120 days of the finding of probable cause. Here, that could easily have happened. The delay was 16 days, which means there was still 44 days for the court to commence a trial. And the Commonwealth, in fact, sought over and over again to have a trial start. So while 16 days, being detained for 16 days against one's will, and beyond the 60 days of 13A, nobody wants that to happen to him. But in light of the statutory scheme, the structure of the whole thing, I think that a limiting principle for what is an acceptable delay is whether or not there is still time for the trial to occur before the 120 days after the finding of probable cause.
You can correct me if I'm wrong, but I guess I thought that our case law accepts that argument up to the 60 days. In other words, if the
Right, the
QE
liberty
reports are a little late, as long as everything gets done within that first 60, so you're just moving that back another 60 days, is that right? And
No,
then
I'm saying when there are extraordinary circumstances.
Okay, so
and-
we have to find first that there are
Absolutely, absolutely. If you don't find that the circumstances are extraordinary, then I lose. But if you do first find that, then you have to ask the second question, well, was the 16-day delay here very brief or extremely brief. Para has both formulations, and I, of course, prefer very brief to extremely brief. But, of course, this court can decide. And I might point out that my brother rather generously says in his brief that he also uses the term very brief delay. So Judge Kern thought that 16 days should be compared to the pre-probable cause delay. And I think that the point is valid, but it doesn't get you all the way there. The respondent has a right to delay probable cause, but in fact there were many, many, many extensions before probable cause was found. I think the key measure for briefness is, as I said, whether or not there is still time for the trial to take place within 120 days. Here there was still ample time, and the prosecutor wanted that to happen, and the defense counsel repeatedly refused to set a trial date. So to that extent, the 16-day delay was within the scope of 120 days, was a very brief period.
Thank you, sir.
Thank you.
Pardon me? Okay.